You've just been convicted by a court and sentenced. You believe the judgment is wrong, so you immediately file an appeal. But appeals can take months or even years. So here's the question. Will you have to spend those years in jail before the higher court even decides whether the conviction was correct? The answer is not necessarily. This is where the remedy of suspension of sentence comes in. It means the higher court temporarily pauses the punishment awarded by the trial court until the appeal is decided. The conviction still exists, but the punishment is put on hold for the time being, because justice must remain meaningful. Imagine someone is sentenced to 3 years in prison. If the appeal is decided after 4 years, the entire sentence would already have been served. Now imagine the higher court later finds that the conviction was wrong. Those years spent in prison can never be returned. That's why courts have the power to suspend a sentence while an appeal is pending. The main provision is Section 389 of the Criminal Procedure Code, now substantially continued under Section 430 of the BNSS. But suspension of sentence is not automatic. In Atul Tripathi versus State of UP, the Supreme Court made it clear that courts must examine the seriousness of the offense, the length of the sentence, the strength of the appeal, the interests of the victim and society before granting this relief. So remember, suspension of sentence does not erase the conviction. It simply ensures that a person is not forced to suffer a punishment that may later be found unjust when the appeal is finally decided. And if you want to go beyond theory and actually learn how suspension applications are drafted, argued, and decided in real court situations, join Ednectar and simulate the complete criminal procedure through practical learning.